Right, let's go for it. Morning, everybody, and welcome to this webinar in our Shoesmith's Shared and Halved series on COVID-19 affected topics. My name is Sebastian Price. I'm a partner in Shoesmith's commercial group, and I'm chairing today's webinar. Let me just explain a bit about our Shared and Halved programme. And actually, as we move on from just thinking about the problems brought by COVID-19, sharing and helping each other with those problems, what we want to do is focus more and more on the new how, which is how we're going to operate and flourish in the new situation. So what we're doing is bringing together interest groups to share thoughts and answer questions, and this one for in-house lawyers. They're intended for a half-hour coffee break to give you a bite-sized session with practical tips. Thank you very much for the questions and thoughts you've been sending in. It's great to keep up a conversation with you all. Please do carry on, send us those questions, and keep an eye on our main COVID-19 hub on our website. There's a special area, special page there for in-house lawyers. We're putting up useful resources for you there, which will include the key takeaway notes from this session and actually a recording of this session as well. And of course, we want these sessions to be in line with what's useful for you, so please do send us in your thoughts, questions on anything you want us to cover, and we can shape webinars around those topics. So, as I say, we want to help you be ready for new ways of operating, new rules, new anything. So it's not just about coping, it's about getting back to flourishing, and we call it the new how. Anyway, so in this session, competition law, we're looking at competition law strategies in the COVID-19 situation. And don't forget, if you've got any questions during the session, please just send them in using the Q&A function. We'll try and answer them during the session. So let me introduce our speakers on the panel. We've got Simon Barnes and Angela Gregson from our competition law team. And right at the moment, they're both involved in some cases of businesses cooperating in the supply chain and also in merger control situations. So I think they're going to have some very topical insights in what we need to look out for at the moment. So Simon, perhaps I could just start with you, and just generally, I mean, does competition law continue to apply in this sort of emergency situation?
That is a question that we have been asked over the last few weeks. I think, to be honest, more in hope than expectation. It won't surprise you to hear that the answer is yes, competition law does still continue to apply at the moment. This would be an extremely short seminar if it didn't. So competition law does continue to apply in the ordinary way. So the prohibition of anti-competitive agreements and the prohibition of the abuse of a dominant market position are still there, are still in force, subject to some very minor exceptions that we touch upon in a few minutes. So, for the in-house lawyers, which make up most of our audience today, I think, the usual watch-outs apply. Collaborations with competitors, discussions between suppliers and resellers regarding resale prices, sales restrictions, managing selective distribution systems for businesses that are in the envious situation of having dominant market positions, being very careful not to act in a way that could be perceived as misusing your dominant market position. They all still apply. Now, COVID-19 is relevant, and to the extent that you should be relieved to hear that the Competition Authority, the Competition and Markets Authority, or the CMA, is alive to the reality. It's easy to knock the CMA, quite frankly, but they have actually, I think, very, very quick off the mark. And way back in March, so I think it was very shortly after lockdown, the CMA issued a new guidance document regarding how it will apply competition law in the context of COVID-19. Now, to some extent, again, we can touch upon this perhaps in a few minutes, Sebastian, but to some extent that is a very helpful document because it does offer some comfort to businesses as to how the CMA will take into account current circumstances when it decides whether to apply competition law and how it will apply competition law. But to come back to your question, the CMA also uses that document to underline, and in fact treble underline, the fact that COVID-19 does not create a free pass, as the CMA calls it. It doesn't create an excuse to act in a way that would otherwise be unlawful.
Oh, okay. Well, let's think about some of the things that you said about that comfort for businesses that they mention. Angela, perhaps I could turn to you, and could you expand on that? I mean, does the guidance suggest that the CMA is going to be sympathetic to these pressures businesses are under at the moment?
Thanks, Sebastian. To some extent, the CMA guidance does suggest a somewhat sympathetic attitude. So it allows for temporary cooperation between businesses to ensure security of supply and fair distribution of scarce products or services to consumers. And the CMA's policy is not to enforce competition law, provided that the cooperation is appropriate and necessary to avoid a shortage or ensure security of supply, is in the public interest, contributes to the benefit or well-being of consumers, deals with critical issues that arise as a result of the pandemic and last no longer than is necessary to deal with those critical issues. So in some cases, practices will be automatically exempt from the application of competition law where they meet the normal requirements for individual exemption. So that is, provided the cooperation produces efficiencies which are passed on to consumers and the cooperation is necessary to produce those efficiencies, going no further than is necessary. That means basically they are temporary and they allow competition to remain insofar as possible. So the CMA is also expressing sympathy towards the pressures that businesses are currently under due to the pandemic in many other ways. For example, relaxing the competition rules as just mentioned, but also taking a more flexible approach during the administration of cases, such as allowing businesses extra time to respond to requests or giving them advance notice of requests, for example, in the context of a merger control process. And even, we have seen cases where deals have been provisionally cleared on the basis that the target entity is likely to exit the market absent the transaction, given the pressures that the COVID-19 crisis is placing on some businesses. So I'm thinking there about the CMA's recent provisional clearance of Amazon's acquisition of Deliveroo, which was found to be particularly affected by the COVID-19 crisis. However, the CMA is clear that it will not tolerate opportunistic conduct which seeks to exploit the crisis and has set up a COVID-19 task force to monitor competition and consumer violations. So anti-competitive practices that will certainly not escape enforcement include businesses exchanging commercially sensitive information in circumstances where it's not appropriate and necessary to alleviate the impact of COVID-19, businesses abusing a dominant market position to dramatically inflate prices above a normal market price, or businesses colluding to keep prices artificially high. So to date, the CMA has received around 60,000 complaints over business practices during the pandemic, including for practices such as price gouging for domestic products like hand sanitizer, and it has openly said that it will not hesitate to take enforcement action under competition law where there is cause to do so for those practices.
Right. Well, Angela, I just imagine it must be difficult, well, very difficult for an in-house lawyer to work out what to do. I mean, say they hear that the business is planning to have some conversations with a competitor, or has already had some conversations with a competitor. Can you give a few tips on how an IHL should sort of approach that situation?
Sure. I mean, given the very severe penalties that may be imposed for breaching competition law, including in some cases a potential prison sentence for the worst type of infringement, as well as hefty fines of up to 10% global group turnover, cooperating with competitors is certainly not something that that any business should do without taking specialist legal advice from a competition expert. So in the majority of cases, it is very much business as usual for competition law enforcement, and the stakes are high if you get it wrong. So we would recommend that you get in touch with a specialist if you are thinking about cooperating with a competitor. And we would need to know details such as the rationale for the cooperation, the market shares of the parties, what efficiencies are expected to result, and whether these will be passed on to consumers in order to provide an opinion on whether the cooperation would be exempt from competition law. It also makes sense more generally to carry on with normal compliance practices to raise awareness of competition issues. And, the greater informed your employees are within your business, the better able you are to guard against competition infringement. So implementing a competition law training programme and a competition compliance policy still very much advised despite the pandemic that we're currently facing.
Sure. Okay. No, that's
If I can jump in there, actually, just the reality is we have seen over the last few weeks, perhaps almost inevitably, a number of mini crises or near misses, depending on how you might like to put it. And we have some. We're asked to advise sort of proactively on cooperation, collaboration, sort of things that tend to cross the legal team's path, and somebody sensibly says, "Oh, we need to consider this from a competition perspective." But we have had quite a lot of crisis management queries, even more so than normal in the last few weeks. And just a couple of examples. We've had one business we work with where quite a senior member of management within the business clearly was scratching his head thinking, how are we going to deal with a particular logistical issue relating to getting our product to our customers? Put two and two together and realised his competitors were probably having the same issue, so picked up the phone to them to ask them how they were doing it and see if they could agree, a way of doing it in a coordinated fashion. That was a call probably made with the best of intentions, no ill intent to act anti-competitively, but is that something that one would normally feel comfortable with anybody in a business doing, picking up the phone to their competitor, asking them how they're dealing with a particular commercial issue? Clearly presents considerable risk from a competition perspective. On the other side of the fence, sometimes people can be put into difficult situations through no fault of their own. We've had another client who one of their, again, senior business people received a LinkedIn invite out of the blue from their counterpart at a competitor, and this LinkedIn invite said, "Hi, just wondering how you're doing. Do you fancy a chat?" But in that LinkedIn invite, the competitor included some sensitive information about how the competitor was handling a particular COVID-19 related issue that would have impact on our client. And actually, that through no fault of their own, put the individual at our client who received that invite into a difficult situation, because competition law is very tough if you receive information from a competitor, even if it's not your fault. So as Angela says, keeping your finger on the pulse in terms of day-to-day compliance is really, really important, alongside proactively considering forms of cooperation and bigger ticket issues where certainly preemptive advice is needed.
Yeah. Okay. No, thank you both. That's very useful. And I know you're both saying competition law continues, etc. But I mean, the grocery sector. I mean, I've seen surely that things must have been relaxed in that sector. Is that true or not?
Actually, that is true, and just pick up on Angela's points a couple of minutes ago, that the CMA in some ways is in quite a difficult situation, because the CMA has to apply competition law. It can't change the law. It can't disapply the law. All it can do to some extent is you exercise its discretion as to when it enforces the law. But even with the CMA and the guidance, as Angela explained, it offers some comfort that in some circumstances the CMA will not enforce, won't exercise its discretion to enforce the law. But that doesn't give complete certainty to businesses, because there's still the possibility of private damages claims and so on. What has happened in certain sectors, and the supermarkets sector is one, but also the dairy industry, healthcare, certain parts of healthcare, and Isle of Wight ferries, of all things, government has actually stepped in, and as far as I'm aware, excuse me, this is the first time this has happened, as far as I'm aware, but the government has used, and until now, pretty unknown part of the Competition Act, which allows governments to disapply competition law for public policy reasons on a temporary basis. And so now, in the past few weeks, there have been orders come through Parliament that in relation to groceries, which applies to both supermarkets and grocery suppliers, and in fact logistics services providers in that sector too, and as I said, the dairy industry and healthcare and Isle of Wight ferries, certain types of collaboration between competitors in those sectors are excluded from competition law to the extent that they are genuinely intended to manage supply disruption issues resulting from COVID-19. Now, interestingly, those agreements to fall within the exclusion, they have to be notified to government, and government is publishing a register of agreements that have been notified to it. And in the way of these things, when you organise training sessions like this, overnight government has published for the first time a list of the agreements. So there are, I think it's 13 agreements in the supermarkets sector that have been notified. So they are excluded. So anyone listening to this who is in one of those sectors, so again, groceries, dairy, healthcare, or Isle of Wight ferries, be aware of these exclusions. They may well be very useful if you need to collaborate in your sector to ensure continuity of supplies. But people in other sectors, which I think is probably most, if not all of our audience, those exclusions do not apply, and unfortunately there isn't really any read across, because those are particular sectors where government has disapplied competition law. In other sectors, the law continues to apply. What I would add, though, and I had a conversation last week with a client in a completely different sector, where actually collaboration and sharing facilities between competitors sounds a very sensible thing to do, and it may well be in that sector that they may well contact government and ask whether there can be an exclusion in their sector. So there could be further exclusions where it's merited.
Okay. Now, a stat you mentioned earlier, did you say there's something like 60,000 referrals or something to the CMA? I mean, a crazy number. So, I mean, how are the CMA coping? I mean, let alone that volume. I mean, are they operating from home as well, like everybody else?
Angela, you answer that, because Angela's been battling with the CMA on a couple of fronts recently, and actually you've seen the transition into COVID, into lockdown, haven't you? So go for it.
Thanks, Simon. So absolutely, the CMA is continuing to operate and works to the same statutory deadlines on its cases. So being subject to a Competition Act or merger investigation, therefore, continues to be a very demanding and pressured experience. So the CMA is exclusively holding meetings and hearings over video conference at the moment, with no in-person meetings allowed. And I've recently been speaking to the CMA about organising a virtual site visit in connection with a Phase 2 merger inquiry. So outside of the pandemic, such a visit would take place in person on site, and we've had to think very carefully about how to best maximise the impact of the site visit when carrying it out on a virtual remote platform. So sort of thinking about having an individual from the business walking around the site with a video camera to record a video that we can then share with the CMA over a video conference. It's not ideal, and obviously the pandemic is creating challenges for all of us, but the CMA has adapted like the rest of us have, and moved quite quickly to holding hearings and meetings virtually through video conference. And it is working. You know, it's. I think these things are always better and more impactful in person, but it is serving the purpose, and it is working. But because of the way that the CMA operates, it operates to statutory deadlines in performing its functions. So it's got a specific time period within which it needs to reach a decision. So whilst they sort of are trying to be sympathetic to the pressures that businesses are under, nevertheless, ultimately, because they're working to their own deadline, they do still set very tight deadlines to respond to information requests. And that's something that will remain.
Okay.
For those of you worried about the risk of dawn raids, which I know sits on lots of in-house lawyers' worry lists, that's probably not something you need to worry about for the foreseeable future. But one thing that does cross our mind is we would not be surprised at all if there are a number of CMA investigations, admittedly not next week, but in the coming weeks or coming months, where those investigations relate to how businesses have acted under the current circumstances. But I think your chances of being dawn raided in the foreseeable future, fortunately, are nil.
Right.
There you go. You don't often get a guarantee from a lawyer.
Yeah, we'll hold you to that side. Okay, interesting. So, hang on. Yeah, well, we haven't really talked much about mergers at the moment. And I would have thought, I mean, surely if you're going to take over a competitor that's failing, I mean, surely whatever happens, that must be allowed just to keep the business going. Well, I mean, what would you say to that, Simon?
Yes, and as Angela's touched on, where there's an acquisition in circumstance where the target company is failing and is at real risk of leaving the market, then yes, it may well be. That's a fact the CMA certainly takes into account when looking at mergers. I have to say I've received a number of contacts in the last few weeks from clients in all sorts of industries asking the question, which essentially is now a good time to make a bid for our closest competitor or one of our closest competitors, because either is the CMA less likely to have its eye on the ball and might miss a merger and not investigate, and there may be some truth in that, but that's quite high risk stakes. Or, if we do buy one of our competitors at the moment, will the CMA, in light of COVID-19, take into account the pressures that businesses are under, and will that make it more likely that they will clear the deal? Now, the answer on that second question is a bit of yes and no. I mean, the no element is that the CMA a few weeks ago published, I think, knowing that people are asking this sort of question, the CMA published new guidance or refreshed guidance setting out its approach to assessing mergers on competition grounds. In the preamble or the covering email to that announcement to that guidance, the CMA makes very, very clear that COVID-19 does not change the way in which it assesses the competition aspects of deals. So fundamentally the same rules apply. But you're absolutely right, Sebastian, and as Angela's already alluded to, there is a concept of, if you are a business buying a target company where the target company would, absent the deal, fail and exit from the market, that might well give you grounds for arguing the deal cannot be anti-competitive. Now, there are quite a lot of conditions that apply to that, and it certainly does not give people carte blanche, but it's certainly a question that we're being asked fairly consistently at the moment.
So if I'm a in-house lawyer, my business is talking about one of these deals, how should I approach that situation, Simon?
Well, I think you approach it in the same way that you ordinarily would. So you start off by assessing whether the target company might be perceived as a competitor, or indeed whether there may be an important supplier-customer, a vertical relationship between the businesses, because that can sometimes give rise to concerns in itself. And you would do the sort of preemptive analysis that you would usually do to assess whether you perceived it was likely the CMA would have concerns about the deal. And we have quite a complicated merger control jurisdiction in the UK because you don't have to notify anything to the CMA. So the vast majority of deals actually that we advise on ultimately do not get reviewed by the CMA, and that's great. But there are some deals that either parties choose to notify to the CMA because they want the certainty clearance, and there are other deals that the parties don't notify, but the CMA picks up on and investigates anyway. And all of that's applying in the same way, so all the same sorts of questions and sort of upfront work, needs to be done. An additional consideration at the moment, in particular, though, is failing firm consideration. Is there a genuine prospect that the target would have left the market? And if so, can it be argued, in addition to all the other points you'd want as to why the deal should be allowed, can it also be argued that there's no impact on competition because the target would have left the market anyway? The other two additional points I'm going to throw in here, actually, which I'm looking at Andrew on this, and I will agree with this because we see this time and time again, not specifically COVID-19 related, but to the extent anyone is considering any corporate deals. Point number one, be very, very careful about any documents that you produce in the context of those deals, because the CMA is crawling all over businesses' internal documents to see how businesses, they perceive internal documents to give businesses sort of real life view on the impact of a merger on the market, not the view that they choose to tell the CMA through their carefully crafted submissions. And point number two, just remember that a business you're planning to merge with or buy or be bought by, if they're a competitor of yours, they are a competitor until the deal is completed. So the fact you may be contemplating a merger does not give anybody an excuse to start discussing commercially sensitive information that you would not normally feel comfortable talking about under competition law.
Right, okay. So just perhaps to wrap up, can I ask each of you, if it's not an unfair question, what would you say the sort of the biggest watch outs for businesses with regard to competition law currently?
Well, I mean, certainly on the one hand, the pandemic may create limited opportunities for collaboration, which might not previously have been possible, in the sense that there is greater scope at the moment to argue that cooperation is necessary, for example, to ensure supply in the context of the pandemic. And therefore, there's more of sort of potentially an exemption case available in certain circumstances. But that is certainly not a sort of get out of jail free card. Competition law does very much continue to apply.
Yeah, and I think for my part, just to add, all businesses need to remember, and this is a message probably principally for the commercial people rather than the legal people, because this is more obvious to the legal people, but all businesses need to remember that competition law continues to apply, and COVID-19 does not create any excuses to act in a way that people would not feel comfortable acting ordinarily. And I already mentioned a couple of near misses or crises we've had to manage with people, again, with the best of intentions and probably without intending to act anti-competitively, have done things, said things, had contacts with their competitors that ordinarily they probably wouldn't have even dreamed of doing. And similarly, we've got a number of businesses who are at risk of being dominant, and I think those businesses also particularly even more sensitive at the moment with regard to the risk that the way they respond to COVID-19 challenges, which might include necessary price rises, it might include how they allocate scarce supply, they can be perceived to be an increased risk of challenge at the moment. We are seeing businesses dust off and refresh compliance programs. In some ways now is actually a really good time to do it, because we're all sitting at home, and lots of us perhaps have, or lots of people perhaps have a bit more time on their hands to catch up on their e-learning or to do remote webinars like this. And I think for the in-house lawyer community, my two takeaways are, first of all, we're all distant from each other, but we're all, I think most of us remarkably well actually keeping in touch. But to the extent you possibly can, make sure that you maintain that awareness of competition law compliance, and indeed all other areas of compliance within your business, because the fact we're all working at home, the fact times are tough, doesn't mean the rules go away. They still apply. So do consider whether now might be a good time to give people some refresher training. But my second point, I think, being realistic, do recognise that over the coming weeks and probably months, there are likely to be opportunities for people within businesses, quite frankly, to get it wrong, to mess up and do things that they shouldn't. And with hindsight, they probably recognise they shouldn't. But that potentially creates crises that need to be managed. So do stay alert to that risk and do the best that you can to keep your business and your colleagues safe.
Well, that's great. That's really helpful. Thank you both very much. Time to wrap up. And Simon, you mentioned staying in touch, and it's great to stay in touch with everybody through events such as this. So thank you very much for joining in. And I hope to see you at the next one we've got planned, which is next Wednesday, which is about planning for a safe return to work. So for now, thank you, Angela. Thank you, Simon. Thank you, everybody, for joining. And goodbye. Goodbye for now.
Thank you.